Hello, I'm Rodger Citron. This is a Touro Law Review podcast, and we have a very topical subject and a very informative guest today. The topic is political gerrymandering and election law, and our guest is Ruth Greenwood. She is an assistant clinical professor and the director of the Election Law Clinic at Harvard Law School. And so, Ruth, if I may call you that.
Of
Thank you
course.
so much for thank you so much for joining us today. And my first question, this is how we always start on the podcast, is can you please just tell us a little bit about yourself?
Yeah, well, thank you for having me. So you will soon hear, right? I have an Australian accent. I guess I should start there. I grew up in Australia, and came to the US in 2008, to study. I wanted to study constitutional law and comparative constitutional law. You don't have as many sort of electives or ability to specialize in an Australian law degree. I came to the greatest city in the world, New York, and went to Columbia. And while I was there, I volunteered with the law school Democrats, right? Um, my partisanship, I guess, in America was driven by the fact that the Iraq War had happened while I was at college, and my friend went off and like fought in Iraq and Afghanistan. And it just seemed very foreign and distant. And I was like, wow, it really matters who ends up in control in the US. I went and volunteered on the Obama campaign, just for a week beforehand. They put me down, and I was like, look, I don't know if my accent's like unhelpful. And they were like, look, just do like voter protection. And I was like, what am I protecting them from? And so I was down in Prince William County, Virginia, a majority Black county. And the weekend before the election, there were like notice boards up with signs that looked like they were from the Board of Elections saying, we expect, unprecedented turnout, and so Republicans will vote on Tuesday and Democrats will vote on Wednesday. And I was like, well, what? Like, I thought I was coming to the world's greatest democracy, and this is what I get. So I became interested in election law, and then Nate Persily was teaching election law at Columbia when I was there, and he is a sort of master of all things, but was very sort of skilled up on redistricting. And I found it just so interesting because Australia had been through, partisan redistricting, and then eventually got rid of it and has independent commissions doing its districts. I did that, and then I was able to stay and work in some nonprofits for a little bit, still thinking I would go back to Australia. But then along the way, I met a boy. And so he is now my husband and father of my kids. He was also sort of had a Nate Persily as a mentor. And so we both do election law and voting rights. And we ended up litigating together. And I've just ended up staying, and I've seen some real wild times, right? From the Obama years to Trump and then Biden and then Trump again. I now think of, at the beginning, I thought of myself very much as a citizen of the world, like here I am to make sure that America's democracy is functioning. And now it's a real dual feeling, right? I'm an American, I have American kids. I want this country to function for us, but I still have that feeling of being a person in the world who cares that like it should be a functioning democracy if you guys are out there telling the world kind of how to operate.
Yes, yes. And tell me a little bit about your position at Harvard. It seems like, from when I was reading the bio, you're right in, you'll know this expression, right? You're right in the thicket with election law. What do you do at
Yeah.
Harvard?
Yeah, so for most of my career, have been working at nonprofits doing litigation. I sort of decided to try to focus on things. I was out in Chicago, right? So I followed Nick, my husband, to Chicago, and was like, okay, well, there are some like a couple of things I cared about, particularly partisan gerrymandering, as I've mentioned, right? It seems just kind of ridiculous that there is still partisan gerrymandering, and then also minority representation in the city of Chicago. Is still very segregated, but the suburbs are becoming less and less segregated. And so the Voting Rights Act was less able to enfranchise communities of color there. So anyway, I had a conversation where Nick sort of had this whole uh, anyway, I can tell you more about how the Whitford and Rucho cases started. But I was doing that, and then when Nick moved over to Harvard, they were like, "Oh, there's real interest from the students in doing an election law clinic." And I was like, "Huh, I guess I could do my nonprofit stuff, through teaching students all the time." And I started out sending students out as externs, but I would take some of them to my organization, the Campaign Legal Center, and they were so good. They were just so good. Like I don't know, just the younger generation. I sound like an old lady. But I was like, no, I want to work with these students all the time. They're so inspiring and come with just incredible talents. And so it has worked out really well to be able to, teach the students through the work that we do, but then inevitably I end up with the students teaching me, because they know more about this particular place they've come from, or this organizing strategy, or this press strategy. So yeah, we do mostly litigation and some advocacy work. There's three of me and two other lawyers. Nick is involved a little bit, and then also 16 students.
Okay, and I don't want to make this too deposition like. Nick would be.
Oh, my husband, Nick Stephanopoulos. Yeah.
Yes. And I'll bet the discussions are really high level. That is for
I do
me a
remember
little bit.
the
Yes.
first time we did a panel together, my mum was like, "Now listen, you two, none of this like dinner table back and forth, back and forth. You've got to slow it down for people." No, yeah, it's weird. I mean, growing up, when I was at college, I was a paralegal, and I remember thinking, God, it's so weird when two lawyers marry each other. Like that's like they just do all the things together. But it's turned out really well. Like we are so interested in the same things. We sort of respect each other's talents, right? He is brilliant at briefing and arguing and sort of high level strategy, and I'm better at like details and trial lawyering and sort of pulling the case together and organizing. And so between us, we work pretty well. Yeah.
And the reason we're talking today, all of this is helpful because you've already said, I think maybe twice already, of course, that you find partisan gerrymandering, I think, both sort of offensive, for lack of a better word. Maybe there's a better way to say that, but also kind of, that is, sort of, I think, sort of puzzling, in that it seems like so obviously problematic. And yet here we are in 2025, where gerrymandering, that is the most sort of overt partisan gerrymandering, seems to be coming to part of the terrain in both electoral politics and election law. And the examples, of course, Texas is doing it, and California seems to be responding to that. Just so everyone's on the same page, what is gerrymandering in the political process, and where does it fit in?
Good point. Yes. So I'm sitting here in Massachusetts, where Elbridge Gerry is from, and he was the guy who drew the first gerrymander. So if any of you can look it up online, right? He was the governor at the time, drawing the Senate districts, and drew something that looked like a salamander around the sort of Boston suburbs, and the local paper called it Gerry's salamander, which turned into gerrymandering. But it's basically trying to draw districts, right? If you have a system where you elect members from single member districts, not everyone does, but if you do, drawing those district lines to seek advantage for something. So you can, racially gerrymander, you can do partisan gerrymandering, you could imagine other types of gerrymandering, you can do incumbent protection, you can reduce competition. But the gerrymandering word really just means trying to gain advantage. If you want a little history, so the original way that people in America gerrymandered was purely just by doing malapportionment, right? So you have 200,000 people in the city, that's one district, and then 100 people in each of 4 other districts, right? And so then the rural voters can have more of a say. So in the 1960s, the court, you mentioned the word thicket, right, decided to step into the political thicket, and they previously had tried to stay out of it and been like, look, that's just politics, that's not us. And then finally it was like, well, wait a second, like that's not, in a country that has an equal protection clause that says people should be treated equally. Having 100,000 people's votes be the same as 100 people's votes isn't equal or close to it. And so you develop this one person, one vote idea. So then the powers that want to stay in power have to think of new ways to gain advantage. And so eventually they start working out, well, we know that these folk are very solid Democrats and these folk are solid Republicans. So this group in the middle that swing, let's subsume them into a district where we can know exactly how the Republicans or Democrats will vote. And so, as I say, both sides do it, but it's a matter of stopping the swing voters from being able to actually swing any districts. And then also, drawing in a way, like one of the cases that I litigated out of Wisconsin in the 2012 election, 52% of the state voted for Democrats, yet 63% of the seats in the state assembly went to Republicans. And so there's questions about should it be exactly proportional or some other thing, but like wrong winner outcomes, I feel like everyone can get behind just feeling wrong, right? Like more people wanted one side, the other side gets in power and does all the things that they want. So yeah, say we quibble around the edges. Partisan gerrymandering is, drawing the lines to advantage your party.
Yes. And under the law now, are there legal constraints on gerrymandering?
Good question. So federally, this other case, Rucho, that I brought up to the Supreme Court is where the Supreme Court, John Roberts, said that partisan gerrymandering claims are not justiciable. They did say that it's offensive to the Constitution, but not justiciable, so we can't do anything about it at the federal level. Now, some states have developed like rules that, or I guess interpretations of their state constitutions that prevent partisan gerrymandering and struck down maps. There are other rules that relate to drawing districts. So at the moment, you have to draw single member districts. Most states, you have to draw contiguous districts, right? The district is in one place, not two little whole like pieces of, put together. And then many other states talk about things like respecting communities of interest, respecting political subdivisions, things like that. But in terms of a federal sort of protection against partisan gerrymandering, it does not exist.
And the case you mentioned that you worked on, the Rucho case, what, like, we only have so much time for the discussion. What's at the heart of the majority opinion in terms of understanding, well, it's not the job of the courts to get involved. And what's the sort of, the reasoning or rationale?
Yeah, I mean, look, I completely disagree with the decision, but the most sympathetic version I can give for why they did what they did is this thing I mentioned to you about it being hard to identify exactly when something is what we classify as a partisan gerrymander and when is it just the pull, haul, and trading of the Democratic branches, right? So like if you can't always predict that it's going to be that if you get 52% of the vote that you'll get, 52 or 55% of the seats. Sometimes things just go weird and votes are distributed. There's like not a uniform swing. And so, what they wanted, they were like, look, we had a lot of math and political science that talked about being able to predict how people will vote. The fact that people are reliably, Republican and Democrat. If people really were, if everybody was truly a swing voter, then it would be almost impossible to do partisan gerrymandering because you wouldn't know whether this person or that person is going to vote one way or another. Like the reason I think that we can feel certain that it exists and the partisans are able to draw maps to their advantage is many people vote one way and they stay voting that way for a long time. And so you can draw districts in that way. Anyway, so Roberts and others basically said, look, this is something for the legislative branches to work out. So the states or Congress, can set whatever limits they want. But for the Supreme Court to step in and start, putting in mathematical formulas to decide which ones are out of bounds and which ones are in bounds, they thought was too difficult.
And Justice Kagan dissented in that case. It was a 5-4. That was, it seems like a long time ago. It was a 5-4 court. And what do you think, or what was the theory of her dissent? I'll ask it that way.
Oh, well, just that what I've been saying, right? Like, sure, in theory, everybody could vote anyway, but in practice, right, there is a body of political science that is extremely trustworthy that can show you that one side will get advantage or another. And the idea that you would let the politicians draw lines to decide who they will represent at every election is anathema to the Constitution. It should be people voting for politicians, right? I am a person, I get to choose who my representative is, and I get to band together with people around me. And I guess she also just said, yeah, like in lots of other areas of law, we're able to look at political science and math and all these other expert areas and say like, yeah, that is a credible theory. And we can use it to judge the outliers. I mean, the other thing that was sort of ridiculous in the Rucho case is that the legislators in that case had said, we are drawing a partisan gerrymander. There was no question of intent. It was like, no, we're trying to draw advantage for Republicans. And then we showed they would have durable advantage for Republicans. And then the last prong that Justice Kagan talked about was like, well, is there some justification? Sometimes you talk about the big sort, or like, Democrats are inefficiently distributed, like maybe there's no way to draw a fair plan. So it's like, sure, if there's no way to draw one, fine, that could be a defense. But in North Carolina, where that case was, actually, if you drew, millions of plans, it has a slight pro-democratic bias because it has all of these democratic cities that form the basis for districts. And they were intentionally either packing everybody right into districts in Charlotte, or in Greensboro, they went through the middle of an HBCU to like break up Democratic voters so that you would have the people in Greensboro wouldn't be able to elect a candidate in either of those two congressional districts. So Justice Kagan was like, look, we at the court are here to protect democracy. That's what the Constitution is establishing. We should be able to step in and do that.
And I just want to sort of stay on because, Roberts has been the Chief Justice now for about 20 years. And there's certain things where he is, where the court, under his leadership, seems to be, right, on the one hand, there's certain things it seems to have no doesn't seem to hesitate to either have the final say, or to involve itself in certain times of questions. And yet here it's this real, it's not our place. And I wonder whether there is something, in other words, is this the justiciability point? Is it sort of unique or specific to election law or gerrymandering, or can you connect, that idea to other aspects of the court's jurisprudence? That is, and so that's sort of a piece. I teach civil procedure, and sometimes I teach administrative law, and so I'm trying to sort of figure out, how does he think of courts here, and how does it line up with in other contexts?
Yeah, so the decision Rucho came down, I was heavily pregnant. So like 2 weeks later, I had a baby and was completely, confused by the world. But Nick wrote an article called The Anti-Caroline Court, right? So Caroline Products talks about protecting discrete and insular minorities. And he just sort of went through identifying all the ways that the Roberts Court completely abandons the people that footnote 4, was written to protect. And I think, and it's not really explainable, I don't think, by anything except partisanship, right? If you look at it, it's like if Republicans are going to win and Democrats are going to lose in most cases. Like every now and then he will do something like the Allen v. Milligan case from a couple of years back, which was, brought by Black voters in Alabama, using the Voting Rights Act under the same way it's been used since, the court set out the test in 1986. And so, Roberts could have struck the whole thing down. And he said, no, this is a fine sort of statutory interpretation. This is okay. And so we still kept the Voting Rights Act. But then you see this term, right? The court has set for re-argument a case that questions the constitutionality of Section 2 and its interaction with racial gerrymandering doctrine. Racial gerrymandering doctrine being a doctrine that came out of white plaintiffs in North Carolina in the 1990s complaining that they were put into minority opportunity districts, and they felt like they race was infecting the process too much. They were purely put in there to elect a Black candidate of choice. And what does this poor lady, this white lady have to say about that? The civil rights group somewhat reclaimed racial gerrymandering in the 2010s as sort of an action that they could use to their advantage, but it's always just doing end runs around the latest thing that the court has done to try to cut off power for systemically marginalized communities, I think.
Yeah, and I wanted to get to the Voting Rights Act, and I'm glad that you did. And if you could just sort of step back, because we've been talking about, the political gerrymandering case in 2019 and so on, and yet there's this also longer story about the Voting Rights Act, which may be culminating in the Louisiana case that you mentioned that's going to be argued this term. And so how does the Voting Rights Act fit into how we think about gerrymandering or the law of gerrymandering?
Yeah, so the Voting Rights Act, I mean, I learned about this, once I came here and so as just a complete outsider, I was like, this is incredible, right? In 1965, various forces worked together, John Lewis and others, and President Johnson, to make sure that we got a Voting Rights Act. And initially, it was trying to make sure that Black people could register and vote, because there had been, through Jim Crow, you can't register, you can't vote, violence, intimidation, and all the rest of it. But over time, right, once Black folk could register and vote, they started getting people, elected. And so there was a response, which is like, okay, well, let's decrease the value of your vote. So this case in 1980 out of Mobile v. Bolden, basically was a 40% Black community. There were 3 people elected to the Mobile County Commission, and they weren't able to elect anyone because they was elected at large. And so, everybody, the 60% white majority chose person 1, and then they also chose person 2, and then they chose person 3. And so this case was brought under the Voting Rights Act, and the court, right, it's 1980, it's right after Washington v. Davis, that says you need intentional discrimination under the 14th Amendment, basically said, we think that under the Voting Rights Act, you need to show they chose the at-large system back in 18 whatever, in order to discriminate against Black voters. So then Congress, in response, 1982, Reagan signed an amendment to the Voting Rights Act that says that it has a results test, right? That if you are not able to elect, if Black voters are not able to elect candidates of their choice, that it falls foul of the Voting Rights Act, and it set out a list of factors that you should look at. The Senate factors essentially get at systemic discrimination, right? Are there differences in terms of employment and education and socioeconomic status and all of these things? So the Supreme Court in 1986 interprets the new version of Section 2 for the first time, and it basically says, yeah, this was written to apply to vote dilution. Vote dilution, much like, partisan gerrymandering, right, is where you are trying to draw a district so that, not always, but usually, white voters are trying to maintain control and stop one or more groups of people of color from getting access to the franchise. I say not always because there are cases where Black or Latino voters try to draw an at-large system to keep out white voters as well. And the Voting Rights Act is there for any racial group to use to try to have equal access to political power. So in 1986, in the Jingles case, the court sets out this test, and it gets used for many, many years. Ellen Katz at the University of Michigan has a whole database online, the Voting Rights Institute, that tracks every Section 2 case that's ever happened. You can get huge amounts of detail about those cases. But basically, over time, we see much more descriptive representation, right? You actually get people of color into office, so Black and Latino and Asian and Native American people into office. And we see better substantive representation. Black and Latino and Asian and Native American people are able to get their policies enacted. It applies at the school board level, it applies at counties and cities, it applies at state, House and Senate, it applies at Congress. And so, we have a congressional Black caucus because we have all these minority opportunity districts that are electing candidates of choice of Black voters, which in the 1980s were much more Black people themselves, Black voters would tend to elect people who were also Black. These days, it can cross all kinds of lines, but you can look at the numbers and say, is this person that's getting elected a candidate of choice of a particular racial community? And in circumstances where there are candidates of choice that are consistently getting defeated because white voters are choosing a different candidate, the Voting Rights Act has something to say about that. There are lots of places that the Voting Rights Act won't apply to because there's not this difference in sort of Black-white voting or Black, white-Latino voting. But where it does apply heavily in the South, it is an engine to ensure access to equal representation. I don't know if you want me to talk about the Cala case, the Louisiana.
Sure.
Yeah. So
yes. And I think that you may have been just about to say this, but of course, I believe you're involved
yes.
in the case.
Yeah, so my clinic, I haven't been heavily involved. One of my attorneys and some students have been involved in the Cala case, so I should put that out there to start. But essentially, there was a prior case which we were involved with as well, Robinson v. Landry. So a number of Black plaintiffs in Louisiana said, hey, there's one minority opportunity district, one district where Black voters are able to elect a candidate of choice, but you can draw two. And one of the tests under the Voting Rights Act is, can you actually draw something better? And they were like, yep, there's a second one you can draw. After that Alabama case I mentioned, Milligan came down. They just applied the regular old test, and they said, "Yep, you should be able to draw two minority opportunity districts for Louisiana Congress." In response, Louisiana, rather than having the court provide them a map, did their own new version, wherein they drew two minority opportunity districts out of their 6 congressional districts. Then some white plaintiffs in the North sued to say they thought it was a racial gerrymander, right? You've put us into this district and you have only used race, or race has predominated in the way you have drawn this district. And the response was, well, sure, race is one of the factors. And the reason it's a factor is because we were trying to comply with Section 2 of the Voting Rights Act, right? Once race predominates, then the test is, do you have a compelling government interest and is it narrowly tailored? So the compelling government interest from the state was we are trying to comply with Section 2. They also said there was a whole fight because they wanted to protect their incumbents. They had Mike Johnson, and they wanted to make sure his seat was safe and ready to go. Louisiana has kind of unprecedented power. And then is it Scalise, another sort of leader in the House. They were like, we need these 2 seats to be safe so Louisiana maintains its power in the US Congress. And that meant sort of screwing over one of the other incumbents. And so they had political reasons for what they were doing. They had Voting Rights Act reasons for what they were doing. And the white plaintiffs sued to say, no, we think it was race all the way down. A 3-judge panel said, we think it was, predominantly race with no justification. And now that has got appealed to the Supreme Court. They actually heard argument last term about the facts of this specific case, right? Is it really politics that's being involved here? The court has always said we've assumed without deciding that compliance with Section 2 is a legitimate reason to draw districts where you consider race in the drawing. And then at the last day where we thought we would get the Cala decision, the court set it for re-argument. So on October 15, it will be argued. And they specifically asked for briefing on this question of the intersection. Like, does Section 2 essentially require you to engage in racial gerrymandering? Does it require you to fall foul of the 14th Amendment? And I don't think it does, but we'll see what the Supreme Court says.
Since the oral argument and any orders relating to the re-argument decision, can you, tea leaves such as they are, what's going on, or what's your sense of where the case could end up? My sense, and I'm a much more casual observer, right, is that, but there's this discussion of, oh, this is it. They're going to, that is, this will be the end of Section 2.
Yeah, I mean, so the half empty version, I'm Kavanaugh is the one who has talked about, I think, called the temporal argument, right? In his concurrence in Milligan, he's like, I'd be interested in this argument being, is there a sunset, right, time on when we no longer need Section 2 anymore? And then they referred to specific briefing pages that talked about that. So maybe Kavanaugh's like, we need to hear more briefing on this because I'm ready to do it. Because in this, Chief Justice Roberts is the 4th, right? There are 3, Kagan, Sotomayor, and Jackson, who have so far shown that they believe in the Voting Rights Act. Roberts is the one who wrote Milligan, right? And so then Kavanaugh was the 5th one going along. So if Kavanaugh's not with them anymore, then we're split in a bad way. I guess so the sort of less optimistic version is like, if he's set up for re-argument, I don't know, can he like save face? If he is there a way that he can save face by maintaining it? I think the way that he would do it is to really delve into what he thinks of as this time thing, right? In the context of affirmative action, there was this like case, that was like, oh, maybe for another 25 years, right? And then SFFA is almost exactly 25 years later. You could imagine, Kavanaugh being like, yeah, look, we could see this and we want it to sunset in 25 years. I think that's wrong as a matter of law because affirmative action didn't have a self-liquidating aspect to it. Section 2, you can't, like, it self-liquidates. Once there's no longer racially polarized voting, once like black and white voters or, voters of different races are no longer stopping each other from getting their elections, once we have cross-racial coalitions, Section 2 doesn't apply. You still have it on the books, but it doesn't apply and you don't use it anywhere. In the rare circumstances, hopefully in the future, where it does apply, you use it and you make sure you have protections for these minorities. I don't think that it's a sort of thing that needs like a 25-year sunset clause. My other thought was, could it have been the four, right? The liberals and the Chief Justice who were like, look, if you're going to strike down Section 2, everybody, we need proper briefing on this. And so maybe they're getting proper briefing in the hope that the court doesn't want to strike it down completely. I will say it matters how they strike it down, right? There's a version of saying it's not congruent and proportional, right, as the enforcement power. And so Congress can't do it. And then that wouldn't affect states' ability to be able to police things like this. There's a version where they say just considering race when you're drawing lines, district lines is always a problem and nobody can ever do it. And that throws a lot more havoc into the system and potentially throws havoc into all disparate impact statutes, right? Like as they in 1982 when they amended it, it's a disparate impact statement. If you can show that it's having a disparate effect on on minority voters or one group of voters as compared to another, then you can get relief. Like that's what they do in employment discrimination and housing discrimination.
So this last, say 5-10 minutes of our conversation, for me are really interesting because, and I will freely acknowledge being, a repository of conventional wisdom. That is, so when I think about voting, I'm like, oh, everything is about, or everything sort of runs through this idea of hyperpartisanship. That is, and yet, I want to make sure that if I understood you right, there's this interesting development about, on the one hand, there have been, in part because of Rucho, right, the even more sort of aggressive, gerrymandering and partisanship concerns, and yet, if this is correct, at the same time, it may be that race in and of itself, that is, at the same time, there may be this kind of partisan gerrymandering. There are cross-racial coalitions, and that's sort of what I heard when you were talking about Section 2 of it's not absurd, it's not crazy to think that going forward it could be, less and less relevant or less and less invoked. And in that sense, it has its own de facto, sunset table or sunset possibility kind of thing. And does that seem? And then I guess it's a descriptive question. Is that the world we live in now? That is,
well, okay,
hyper-partisan, and yet, go ahead.
Right. So if you look at purely the 2020 and 2024 presidential results, right, that is where we saw unprecedented numbers of non-white voters voting for the Republican candidate for Trump. And so if you had that level, that such a low level of the polarization seems to be more like by education, I guess, like more and less educated, and maybe a little urban rural. But it's not young and old, it's not men and women, and it wasn't as much. So if that applied to elections all the way down, right? Not just for president, but if that was in your local school board races, in city council races and so on, if you had black and white people voting together, or I'm using that as a shorthand for people of different races voting together for one candidate and people of other different races voting for a different candidate, then the thing that's the cleavage in that society is not race, right? Because the races are voting for both. It's something else. And so the Voting Rights Act is only looking at racial vote dilution. Now, if there's a different type of dilution and we care about the group that's consistently left out, right? The outs not having their way and the ins having their way, then there are ways to to look at that potentially through, state statutes, federal statutes, and potentially, state and federal constitutional actions. But as I say, it's the lockout that was so offensive in the 1960s. It was like very clear. Here's a group of people that are completely locked out of power. And as I say now, if you look in Louisiana, it's like, yeah, Black voters are locked into one out district and they can't get any of the others, but you can draw it to give them two. Whereas in other places, I lived in Chicago for many years, and I think in the primaries, there's much more racial polarization. But once you get to the general election, I mean, the city council is like, I think all Democrats or mostly. And so there's not a lot of polarization by race at that point. So, you have to sort of see what the conditions are on the ground. But you're right, there's a version where the Voting Rights Act, I think this is what it should be, right? It should stay on the books in case we end up in this situation again where we're locking people out by race. And that, as I say, it doesn't have to be non-white people, right? Like you have all these states that are becoming plurality or majority minority. White voters could be the ones that are left out, right? They would very much want, I would think, the Voting Rights Act to help them if they were locked out. But so long as we don't have racial polarization or we don't have, the conditions that you need to make out a claim, well, fine, right? Do something, do something else. We don't need to like bring these cases. And the evidence for that, as I said, from this Ellen Katz's database, it's like, yeah, there were lots of cases in the 80s, less in the 90s, and they've been less because places are getting better at complying themselves, I guess. And also places there's just less polarization. So not everywhere, needs to try to make districts to ensure that particular ethnic minorities can elect candidates of choice.
Can I ask this? When we talk back up to the Louisiana case that's going to be re-argued, the was there any thought on those, sort of advocating for the retention and application of the Voting Rights Act? I believe they were in the position, right, of having to seek certiorari or of appeal up from the lower court.
Yeah, well, they were trying to overturn the racial gerrymandering decision. Yeah. So I wasn't involved in that decision, but the decision was the opinion that came down was that the map was a racial gerrymander, so they should go back to only having one minority opportunity district. And my guess is that the thinking was, well, wait a second, the Voting Rights Act entitles us to two, right? You literally had this decision that told us that there has to be a way to draw, and maybe the plan should be different or whatever, but there has to be a way to draw districts that allow for two opportunity districts. And so I presume that's why I should say it's not a petition for cert, because you get a 3-judge panel challenging constitutionality. So it's like, if they decided to ask for Supreme Court review, then the Supreme Court could summarily affirm, summarily reverse, or take the case. And so they took the case and heard it for argument. If you look at the briefs, obviously there's a lot about constitutionality of Section 2, but there's a whole bunch of other procedural reasons why this might not be the right vehicle for that even to be discussed, right? Because as I say, it was a racial gerrymandering case and it has all of these other things going on. And so there is also a version where the Supreme Court sort of leans into that and is like, oh, wait a second, like that's not squarely the issue before us. Like we won't take it on that. We'll send it back on this procedural question. So I'm not good at predicting what they're going to do. But
yeah, no. And the thing that was sort of floating around, but was just, was there a thought of don't appeal? That is
Well, I know that case out of the Eighth Circuit, the ACLU's case on the private right of action under Section 2, they didn't appeal that up to the Supreme Court. That would have been on cert. But I think with the idea that like, okay, we got this bad ruling that applies to the Eighth Circuit that says that you can't bring a Section 2 case as a private party, only the government can bring it. But if they appealed it up to the Supreme Court, it could apply to every circuit everywhere. And so I don't know if that's the reason they didn't appeal, but it's plausible that that was the reason. So I think you're right. I think people are thinking about, I remember when I first started doing the Whitford case, I was like, we've got to get to the Supreme Court and get them to strike down partisan gerrymandering. And now I teach my students, avoid the Supreme Court. If you care about voting rights, avoid the Supreme Court. But yeah, then there's also the interests of clients and so on. So I'm not sure what the various considerations were. But there is a thing of, like even with the Milligan case, it's like, and this is what I thought about partisan gerrymandering, right? Like if you're not actually bringing these cases and going up, then what's the point in having them, right? Like why have it on the books if no one's using it because they're all too scared to go to the Supreme Court? And like in Milligan, they forced the court to decide, and the court said, yeah, you know what, this test that's worked for 40 years, we're going to leave it around. Like it's fine.
Yes, I'm reminded of when I worked at a law firm a long, long time ago as a summer associate, and a very impressive partner who I worked with said, "Oh, everything I needed to learn about practicing law, you know, I learned in college, and I was, the managing editor of the school paper, and I played a lot of poker." And you do have to have a stomach for, right, uncertainty and how what cards are going to get turned over at which
Yeah,
time.
well, I think what you have to have, and what I try to teach my students, is you have to have your strategy can't just be we're going to go to the courts the end, right? You need to have an organizing strategy, and you need a community. Like, for example, in Michigan, there was a whole claim about partisan gerrymandering that got kicked when the Rucho decision came down. But already there was a group of activists who were putting had put an initiative on the ballot to get independent redistricting, to be like, we don't need to go through the courts. Let's just take this out of their hands. And now Michigan, actually has a relatively fair map because it was decided not by politicians trying to seek advantage. So I think that to me is the message. It's like, sure, go to the courts
Oh,
for the things that you can, but be outside the courts as much as you can too.
yes, no, so I have to revise when I tell this story to my students and say, well, in the commercial litigation context,
Yes.
this is
Yeah.
how you should think about it. But in other contexts, there may be another way to approach the problem, and the role of courts in it. So I want to come back just real quickly, if I may, to Texas and California. And I believe suits have been filed, certainly I think in Texas. And if I read correctly, I thought it was interesting that the suit was filed in federal court. And I uh, I guess any thoughts about that case, that strategic choice, how that could play out?
Yeah, I mean, I haven't looked at the details of it, but if you tell me that somebody has chosen to file in federal court in Texas instead of state court, I'm guessing it's because they don't think state court's their friend. And there are probably both federal and state causes of action that could be heard, in federal court. I think just to give you my 2 cents, I mean, I think it's appalling what Texas is doing, but I also think that it matters what the partisan bias is of the entire US House. And so for California to respond is the right thing to do. If these states are going to do, it's bad for voters are already kind of, poorly off because of what the court did in Rucho. And so it's already the case that like Democrats in Texas don't really have a say and Republicans in Illinois don't really have a say. That's bad enough. But now once we start trying to, ratchet up advantage, I'm like, look, fine, both sides do it. Like, John Roberts, see what you have reaped.
Um, and well, that actually is there that may be a great place to end. Is there any, there was a judge in the Third Circuit who used to say, is there anything else you'd like to say at the end when somebody was done presenting argument? Is there anything that really you want to add or is part of the picture that we haven't covered so far?
No, I mean, the main thing sorry, there is one thing, which is that my students often come to me worried about whether there's a future in election law. And I don't think everyone needs to do it, but I do think that I see myself as laying the record, right? I don't want to go down without everybody knowing what is happening and why it's happening. And I'm fine to lose case after case because I want there to be a record laid of this time, which I think is very challenging for democracy. And I think it's important that people keep fighting. You can't just, I mean, I said to one of my students, I was like, what are you going to do? Sit in the hole? Like, get out there and go. You got to do something.
Yes, that's even a better place for us to end. And I say it with 100% sincerity. It's really part of the role of being an advocate. Um, you're not always going to win, but that doesn't mean you stop doing your job. So, on that note, thank you so much. That's the end of our podcast.
Thank you. Thank you so much for having me.